Do you have an absolute, unfettered right to silence in the UK? Well, yes and no, because this is commonly misunderstood. So some people understand the right to silence, meaning you don't have to say anything at all, ever. And that's not quite true for reasons that will become clear in this video. But first of all, if you're new to me, I am Daniel Shunsmith, a barrister of England and Wales, and I enjoy helping you to understand law. So please pop that like button and subscribe at any point if you find this video useful. So let's talk about the right to silence first of all. It comes about by way of the police caution. At least most people understand it to come about by way of the police caution. It is actually enshrined in long history of law, which we won't get into in this video. The bottom line is you don't have to say anything, but the police give you a caution. Why do they give you a caution? Because it may harm your defense. If you do not mention something early on, and then you rely on that thing in court, for the simple reason that the prosecutor will invite a jury to conclude that you may have made it up to make your story sound better when you get to court, when all along you had every opportunity to do so beforehand, and it's more likely that you made it up if you didn't mention it before. For a simple example, if you're acting in self-defense, your first words to the police would probably be, "I did it in self-defense." And they should certainly be some of your first words if the police say to you, "Why did you hit this guy?" And your response would probably be, "Well, he was going to attack me, so I hit him in self-defense, officer, to prevent him from hurting me." Then it's self-defense. And so if that's your first response to the police, and that's what you maintain in court and everywhere in between, then you've got a consistent story. If in the first instance, let's twist this a little bit. In the first instance, the police officer said, "Why did you hit this guy?" And you said, "It wasn't me." You've got the wrong person. It wasn't me that did it. Then that is a categoric denial of your involvement in hitting this guy in the first place. But then let's say that they don't believe that, and they charge you with assault because they believe you did hit this guy and you broke his jaw or whatever. And then you end up in court later on. And then in court you say, "Well, all right, yes, I did hit him, but it was self-defense." Now, if you didn't say that it was self-defense at the outset, then the prosecutor is going to invite the jury to conclude that you've changed your story. You now believe that it is more likely that you'll get away with doing this if you now say that it was self-defense, when initially you denied any involvement. You can see how a jury would conclude that you're probably making that up. At least there's a good likelihood you might be making that up. Now, that is why you're given the police caution, to warn you against exactly that, which is what we call an adverse inference. Maintaining silence throughout also produces an adverse inference. It means that you haven't answered any of the allegations against you. Even when you get to court, there's no compulsion upon you to get up in court and give evidence. Although if you don't give evidence, then again, the jury is going to be invited to conclude that you may be guilty because you've refused to give evidence to the contrary. Now, the slight caveat with that is if you want to raise self-defense, there must be at least some evidence of self-defense. That's the evidential burden to raise self-defense, and then the burden shifts back to the prosecutor to disprove that you're acting in self-defense to the same criminal standard. But we digress. Back to the caution. The police caution is, depending on the force, is very slight variations, but by and large it is, you do not have to say anything, but it may harm your defense if you fail to mention when questioned something that you later rely on in court, and anything you do say may be given in evidence. So that covers both of the scenarios I've just given you. One is where you say something, but then you change it later. It may be given in evidence that you said it in the first hand. And if you don't say anything, but then you rely on it, then it may harm your defense. That is, very broadly speaking, the right to silence, both when being questioned and when you get to court. There's all sorts of other rules, such as if you're in a police interview, you have the right to consult the PACE codes. That's the Police and Criminal Evidence Act, which sets out the standards of behaviour of the police. You have the right to free legal advice, and so on. Now, also, obviously, if you're being oppressed to provide information, then also anything you say could be ruled inadmissible because it was unfairly extracted from you. So aside from all that, that is the caution. However, there are situations where you do have to say something, and that includes your name and address, and sometimes even your date of birth and so on. So there are various bits of legislation that give rise to the requirement for you to provide your name and address. One of which is where the police suspect you of either being involved in antisocial behavior or any other kind of offense, and they require your name and address usually, and you are required to provide your name and address in those circumstances, and failure to do so will result in you committing a further offense for which you could be arrested, not least of which because the police can't determine who you are. Other situations, many people misunderstand, for example, dropping litter. The legislation provides that you must provide your name and address in those circumstances, and again, it's an offence not to do so. Another example is being stopped by the police in your vehicle. The police have an unfettered power to stop any motor vehicle on a road or public place under Section 163, and then they can require your name and address in those situations as well as all the other details. For example, insurance under another section. And if you don't provide those, it's a defence to provide it within 7 days, but that is a defence rather than you just let off the hook. It is a defence to provide them. That's commonly known as a producer. But when you're asked for your name, you are required to provide it. And if you don't provide it and you are suspected of being involved in some kind of other offence, you are likely to be arrested to determine who you are. And as I said, failure to provide your name and address in the instances that the legislation requires is amounting to a further offence for which you might also find yourself arrested. So when you hear the term of the right to silence, that is what it's referring to in the first portion of this video. Your right to silence, not to answer to questions about allegations that you've been involved in some offence or another. That is your right to silence. But it doesn't mean that it might not harm your defence. If you remain silent, as the caution goes, it may harm your defence in court if you either don't mention something or you've changed your story. But when you're required to provide your name and address, there are certain situations where you are required to provide your name and address, and those are just a few. And in any event, it makes very common sense that if you are asked for your name and address, you're stopped in the street, "Excuse me, sir, can I confirm your name?" And you just get all argumentative and say, "No, I don't have to give you my name." Well, strictly speaking, you're right if there's no suspicion that you've been involved in antisocial behavior or any other offence. And if you have, they have to tell you the nature, at least, of what the offence is that they suspect you've been involved in. But let's think about this logically and reasonably. If I'm walking down the street and I happen to look like someone that's committed another offence, let's say I'm wearing the same clothes. Let's say he's also bald just like me. I mean, I'm mostly bald. I shave most of it. But anyway, let's say I look like this other guy and they've mixed me up with this guy. And the police say, "Excuse me, sir, can I confirm your name?" I would just confirm my name, and then presumably they've got the wrong person. And if they might say, "Have you got anything with ID to confirm your name?" And I'd say, "Oh yeah, probably. I usually carry my driving license with me." Boop. And I would produce my driving license. I have no issue with that whatsoever. Why? Because I'm not going to do anything wrong. So, they would genuinely have mixed me up with somebody else and want to exclude me from their inquiries. So instead of turning it into a 10, 15-minute argument back and forth with the police, which might result in your arrest, if they form the suspicion because of your behaviour that you might be the guy that's involved in the antisocial behaviour, you might find yourself arrested, all of which a complete waste of time. And in most situations like that, it's not going to amount to an unlawful arrest if they've got the reasonable suspicion that you were that guy. So just, I would suggest being reasonable. Obviously, situations vary and you can make your own determination. But hopefully that was helpful, and hopefully that's helped you to understand. But it is not an absolute unfettered right to remain silent in each and every situation you come across. It's not quite as straightforward as that. But I hope you found that useful. Please pop the like button, subscribe, and I'll see you next time.